The coalition government seems to be split tonight over its approach to secrecy. The Prime Minister says gaps in national security have to be plugged. But his Lib Dem deputy, Nick Clegg, says the proposals to extend the monitoring of internet use and the use of secret evidence in civil courts go too far. Our political correspondent Michael Crick reports now on the fresh strains that the age-old balance between liberty and security are now revealing.
Despite the occasional odd look from Nick Clegg, normally Ken Clarke would be seen as one of the Lib Dem leader's closest Tory allies in Cabinet, especially on rights and liberty issues. But suddenly the Lib Dems are laying out firm red lines as to how far they'll go with proposed new laws, both on intercepting modern communications and now Ken Clarke's plans for secret courts for civil cases and inquests.
Ministers, of course, can argue the case if they're persuaded. But as you know from today, not all ministers are persuaded, not all government ministers are persuaded, the Deputy Prime Minister isn't persuaded. We as a party are not persuaded, and the coalition is a coalition of two parties. They won't get past us.
Since 9/11, the raising of intelligence material in British court cases has grown hugely. And Ken Clarke argues that justice requires we should extend the closed courts which already hear sensitive immigration cases. These are rare shots filmed by Channel 4 News some years ago of the courtroom of the Special Immigration Appeals Commission, SIAC, set up to hear cases where intelligence has to be protected. In a normal court hearing, the two teams, defence and prosecution say, sit on different sides. But in SIAC cases, security-vetted special advocates sit in the middle. When the session goes closed, the defence team have to leave the room, along with the press and public, and the special advocates then argue on the appellant's behalf when intelligence material is heard. Even when the court goes back to open session, there's still no direct contact between the defence team and the special advocates who've been representing them. But does David Cameron share Nick Clegg's concerns about extending such courts?
Government, Prime Ministers have a responsibility for national security. We should take every step that is necessary to keep the country safe. We shouldn't put our civil liberties at risk by doing so, but where there are gaps that need to be plugged, we need to plug those gaps.
One gap ministers want to plug arose in the 2010 Guantanamo Bay case, where, rather than use secret material in court, the government settled and paid £20 million to 16 men who accused MI6 and 5 of abetting their torture. Ministers say that without changes, America may also refuse to share intelligence with Britain.
I think it's odd that we haven't heard a categorical thing from the US that unless we do this, intelligence sharing will be reduced. And Ken Clarke says he hasn't even spoken to the Americans about this. And so it does seem odd that we're looking to completely overhaul our justice system based on a possible threat that we haven't even substantiated.
The curious thing about Nick Clegg's civil liberties objections is why now? After their success in getting George Osborne to raise the income tax threshold and then claim it as a Lib Dem achievement, has the party simply picked on two new issues to show how distinctive they are from the Conservatives? That's especially important right now with local elections only 4 weeks away and the Lib Dems still languishing badly in the polls.
Michael Crick reporting. Well, we're joined now from Oxfordshire by Professor Anthony Glees, Director of the Centre for Security and Intelligence Studies at the University of Buckingham, and in the studio here by the Director of Liberty, Shami Chakrabarti. Professor Glees, do you accept that there is a civil liberty issue here? Justice has to be seen to be done, particularly in some of these very controversial cases.
Well, I think there is a civil liberties issue here. But what Ken Clarke wants to do, rightly in my view, is actually increase the amount of accountability of our secret agencies for our country as a general rule. Now, what's really important to understand is we have secret intelligence agencies. Their job is to keep us as safe as they can. They're not large in number. They deserve our trust. Of course they should be accountable, and of course they should act lawfully. And that is precisely what Ken Clarke wants, because at the moment They don't have to.
Shami Chakrabarti, do you accept that there are things that have to be kept secret to protect national security?
Absolutely, and under the current law of this country, they are kept secret. I think what's interesting is that in Michael Crick's report, he expounded the security service line that they settled the Guantanamo cases rather than expose secret material in court. They never applied for public interest immunity in those cases. They settled those cases on the merits. They were going to lose those cases. But if they'd wanted to protect secrets and they wanted to avoid disclosure of sensitive documents, they could have applied to a judge for immunity. They did not.
Well, Professor Glees, you're shaking your head, but a PPI is a ministerial fief that simply says, look, I'm sorry, we must protect this. Wasn't used in that case, could be used in other cases.
Well, I think what the issue was about was the control principle. That is to say, the unwillingness of British intelligence officers to disclose intelligence that they'd received from our American allies. And rather than present that intelligence in a closed court, they chose not to present the intelligence and to pay out millions of pounds to people, I speculate here, who may not have deserved this. Now, it's all very well to say, oh, the Americans would give us the intelligence in any case. Actually, that isn't true. In 1973, July 1973, the Americans turned the tap of intelligence off, and it caused Edward Heath's government a considerable amount of trouble at that time. Well, you can't force the Americans to give us intelligence, and if I may just finish the point, unless the Americans give us intelligence, our own intelligence services will be three-quarters blind.
That would be all very well if the Americans had a problem themselves in these courts. But you never hear of the Americans ever doing. Indeed, their constitution wouldn't let them do what Ken Clarke wants to do.
Exactly.
So I don't see them as a very good example, do you?
They have the same civil law systems as we do, and you're quite right. What's being proposed here is not permissible in the United States. I think Claire Algar put it very well in Michael Crick's report. There is no on-the-record comment from the American administration saying that intelligence relations would be compromised but for this huge, huge departure from fair trial principles in this country. This is not about prosecuting terrorists. This is not even about deporting terror suspects. This is about protecting the spooks in civil claims from scrutiny.
Professor Glees, you came up at the beginning with Ken Clarke's argument that he's going to make the security services much more accountable. That's been the problem. The thing has been a complete whitewash right up until now. How do you see him doing that?
Well, his proposals are, first of all, to allow in closed courts for intelligence evidence to be given to a judge. And Shami Chakrabarti's refusal to accept the importance of that, frankly, beggars belief. What this is about is serious criminal offences. What this is about is terrorism. It's not about a minor thing. It's a very important matter of national security.
And so we need to clarify this.
Let her just come in there,
I think we have to
Professor
clarify this. This is nothing to do with criminal offences. This is nothing to do with criminal prosecutions. This is nothing to do with control orders or even deportation cases.
It's to do with national security, Shami Chakrabarti. It is to do with national security.
No, it isn't.
At the moment,
it isn't.
Intelligence... No, it isn't. At the moment, intelligence officers are not obliged to give evidence. This will make them more accountable. And the second thing that Ken Clarke said is that the government is planning a reform of the Intelligence and Security Committee to make it more active and to involve Parliament more in its work. As somebody that's written a book about this committee, that is absolutely vital.
This green paper expressly says that this is about public interest cases. It goes way beyond even anyone's definition of national security. What's proposed in this green paper is that in any civil claim where a minister says material is sensitive and it's not in the public interest, that there is even-handed justice, then he will be able to certify for this kind of shadowy closed procedure. It's not just secret courts, it's one-sided courts. It's a private chat with a judge from which one party is excluded.
Quick final word from each of you. Do you accept, Professor Glees, that they've probably overdrawn this act in order to row back to somewhere more manageable? I see that you're nodding your head, Shami Chakrabarti.
Well, what I would say is that the coalition government is in serious trouble if it cannot get policy through which safeguards our national security.
Let's leave it there, Professor
and
Gleeson.
it is about our national security.
Right, thank you both very much indeed. I'm afraid we're going to have to leave it there. Thank you both for coming in.